You're watching FJTN, the Federal Judicial Television Network. The Federal Judicial Center and the United States Sentencing Commission present Sentencing and Guidelines, Economic Crimes and Money Laundering. And now here's your host, Rachel Pierce.
Good afternoon and welcome to our program today. Today's program is a series, and is the latest in a series of collaborative efforts between the Sentencing Commission and the Federal Judicial Center on sentencing and guideline issues. Those of you who have already registered for this program, you were given a link to the website where you can download the information and the material that you'll be needing for today's program. This is also the material that you will need to submit for purposes of CLE credits. For those of you who have not already registered, you can find the information at the following website. That's jnet.fjc.dcn. We also have fax capability today. If at any point during our broadcast you have a question that you would like for our panelists to answer, you can fax that question in to 1-800-488-0397, and we'll do our best to get to those questions today. Today we are going to be focusing on economic crimes and money laundering amendments, those amendments that went into effect November 1st of 2001. However, before we get started with that, I'd like to just give you a little bit of a background about what's going on recently at the Commission with respect to economic crime offenses and specifically corporate fraud offenses. Congress recently enacted the Sarbanes-Oxley Act of 2002. And in that act, there are a number of directives to the Sentencing Commission to increase penalties for serious fraud offenses. For example, if the offense involves significantly more than 50 victims, if the offense endangers the solvency or security of a significant number of victims, if there are officers or directors of publicly traded companies using their position to facilitate the offense, or obstruction of justice offenses in which destruction of evidence occurs in reference to serious fraud offenses. I'd also like to make note here that the statutory penalties for mail and wire fraud have been increased from 5 years to 20 years. Now, in talking about the changes that have been made to the guideline in response to this act, I'm going to focus on three main areas. I'll start out with the changes to the loss table and the loss definition. I'll move on to then talk about some of the changes you'll see with the specific offense characteristics at the fraud guideline at 2B 1.1. And then I'll finish up with the changes relative to obstruction of justice offenses. So getting started with the changes to the loss table. The first thing you're going to see is an expansion at the higher end. You're going to see an offense level increase of 28 for offenses involving between $200 million and $400 million of loss. Offenses that involve greater than $400 million of loss are now going to have a 30 level increase associated with them. You will also see changes at the tax guideline at 2T 4.1, the loss table there, to maintain proportionality between these two guidelines. With respect to the definition of loss, there has been added an extra criteria or an extra factor, if you will, at Application Note 2C for the courts to use in making the determination or the estimation of what loss is. And that is the reduction of the value of equity securities or other corporate assets. So just another aspect that the court can look at in estimating loss in these types of offenses. Moving on to look at specific offense characteristics, starting out with 2B 1.1b2. As a result of this act, we've expanded the existing victim-specific offense characteristic to provide for an increase of 6 levels if the offense involved 250 or more victims. Looking at 2B 1.1 B12b, we've expanded the already existing specific offense characteristic regarding the safety and soundness of a financial institution. It has been expanded to now cover if the offense involves endangering the solvency and financial security of either an organization that was publicly traded or had 1,000 or more employees, or if the offense involved more than 100 victims. Now, the way you'll be able to figure this out if this specific offense characteristic applies is by using the totality of circumstances approach. And the guideline provides a non-exhaustive list of factors that the court can consider in determining whether or not the specific offense characteristic applies. Finally, with specific offense characteristics, there is a new specific offense characteristic at 2B 1.1 B13. This is going to provide for a 4-level increase if the offense involved a violation of securities law and the defendant was an officer or director of a publicly traded company. Now, it's important to remember that this is applied on the basis of relevant conduct and does not require a conviction for a violation of a securities fraud statute. Additionally, if this specific offense characteristic is applied, the abuse of position of trust enhancement at Chapter 3 will not apply. Finally, looking at changes with respect to obstruction of justice offenses, you will see at the 2J 1.2 obstruction of justice guideline, the base offense level has increased from 12 to 14. You'll also see changes in the specific offense characteristics to increase by 2 levels for if the offense involved destruction of documents, if there was a selection of any essential or especially probative document to destroy, or if the offense was otherwise extensive in scope, planning, or preparation. So keep those changes in mind. They did go into effect January 25th, 2003. When you run across serious fraud types of offenses, be aware of those changes. Returning to our topics for today, economic crimes and money laundering, I just want to give you a brief description or a little bit of a background on the policy teams at the Commission. When the Commission is faced with the task of amending the guidelines, they form policy teams. The policy teams are comprised of members of the different offices of the Sentencing Commission. And what these members do is get together and study either congressional directives such as those from the Sarbanes-Oxley Act or Commission initiatives such as the Economic Crime Package and money laundering, and study these initiatives and these directives to make recommendations to the commissioners for appropriate amendment options. We do have with us the chairs of both the economic crime team and the money laundering team, Andy Purdy and Paula Desio. They are both members of the Office of General Counsel at the Sentencing Commission. And we're going to get started today with the economic crimes package and Andy Purdy. Welcome, Andy. Thank you for joining us today.
Pleasure.
Why don't you get us started by just telling us a little bit about the economic crimes package?
Well, there are a number of important elements of the economic crime package, and right now I'll just give an overview of some of the most important, and then we'll go into detail on some of those. First, the consolidation of the theft, fraud, and property destruction guidelines helps eliminate the difficulty that occurred in some cases of choosing which guideline would apply. In addition, the loss table. Now there's a common loss table for all those guidelines, so it has a common base offense level of 6, so theft offenses, instead of having a base of 4, are moved up to 6. In addition, the loss tables, the punishment levels, have been revised for middle and upper loss amounts, so that at loss amounts above $70,000, there's some increase in punishment that gets greater as you move to the higher loss amount figures. Third, there's significant revisions in the definition of loss and the formatting of it to help make it easier to understand. Finally, there are a number of revisions to specific offense characteristics. One that's significant is the elimination of the more than minimal planning enhancement, which applied in over 70% of fraud cases.
Okay, so on one hand we have increases to the loss table and some specific offense characteristics, but on the other hand you also mentioned the deletion of the more than minimal planning specific offense characteristic. So when you have a fraud offense with so many changes in one guideline or one amendment, how do you determine which manual that you're going to be using?
Well, the general rule is the same as with any guideline amendments. You refer to 1B1.11, which is a policy statement, which states first that you use the guidelines in effect at the date of sentencing, unless the ex post facto clause requires that you use the guidelines in effect at the date of the offense. Essentially, when you have numerous provisions, it just means you have to work a little bit harder and be systematic in trying to determine which of those two alternative manuals is going to be the most onerous, and the defendant will be sentenced under the one that is the lesser of the two, but you apply the entire manual. The only exception to applying one manual or the other is for clarifying amendments. Clarifying amendments apply regardless of which guideline manual year you're using.
Okay. Once we've determined which manual we're going to use, I guess the next big issue we have to determine is what the loss is. I know that the Commission has determined that loss is really the best proxy for harm in these types of fraud and even theft offenses. How has the definition of loss changed, if at all, with the Economic Crimes Amendment package?
Well, some of the most important changes we'll detail, but I want to talk also about some of the things that have stayed the same. The general rule is and remains that loss is the greater of actual or intended loss, so that remains unchanged. There is some clarification, though, that certain exclusions apply relative to actual loss, and we'll talk about that. the actual loss definition, rather than essentially being the value of property taken, damaged, or destroyed, is the reasonably foreseeable pecuniary harm that results from the offense. So that's an important change. Now, reasonably foreseeable pecuniary harm is defined, and of course that is going to be a standard that is going to be critical to the judicial fact-finding on what harms are included in loss and what are excluded. And those are the harms that the defendant knew or under the circumstances reasonably should have known were a potential result of the offense. Finally, the guideline amendment makes clear that what we're really talking about the judge doing in general proposition is estimating the loss, that the judge has to give an estimation and must make a reasonable estimation of the loss, but need not be overly detailed in terms of specifics on every single little dollar that's found. Previously, the fair market value of the property taken, damaged, or destroyed was at the core. Now that's one of the elements that's included in the estimation of loss.
Okay, you've introduced to us this concept of reasonably foreseeable pecuniary harm. Now, it sounds like that would include some things that were not included in the loss definition before. Is that the case?
I think that's right. Certainly in certain cases it will include additional things, and it may exclude some things. I encourage everyone to take a look at the Appendix C of the Guideline Manual, which includes the amendments, and in this case it's Amendment 617, to see what the reasons for the amendment are, and that helps give some guidance. Obviously the language of the guideline and the language of the commentary control, but that can give some guidance as to what the Commission intended by the amendments. Now, with respect to reasonable foreseeability, it more clearly articulates the causation standard that is applicable. And what is required now, it's quite explicit that there must be but-for causation. The criminal act must have caused the harm. In addition, of those harms that were caused by the offense, you only include those that were reasonably foreseeable under the standard that I just articulated. So in some cases, some things may be included, whereas before, and some may be eliminated now.
Okay, you also mentioned that there are some exclusions in the loss calculation. Can you tell us what those are?
And these exclusions are relative to actual loss. Two of the big ones. One is interest. Now, before the Guideline Amendment, there was language that excluded interest. But the case law evolved and interpreted things like opportunity cost, bargain for interest, and we had some circuit conflicts. So the Commission made the judgment, made the policy call, and resolved the circuit conflict that interest will not be included in the calculation of loss. Whether it's traditional interest, whether it's opportunity cost, what could have been earned, or even if it's actually bargain for interest. The central concept is that the loss that resulted or the loss that was intended is at the core. Secondly, the cost to the government in connection with the prosecution or the investigation of the offense is not to be included in loss. And the reason for that is that there are in almost every case there are going to be costs associated with the government in investigation and prosecution. And the burden on the court in trying to make that calculation, and the Commission decided it's really not necessary, consistent with our estimation concept, to have to make that calculation. Also, the concept of reasonable foreseeability is often seen in the civil law. And so judges are well versed in how to apply the concept of reasonable foreseeability. But in the criminal sentencing context, the exclusion is that those harms that are to be included in loss are only those that are readily convertible to monetary value. Okay. So that some things that would be included in the civil context, such as emotional distress, harm to reputation, or other non-economic harms, are not to be included and need not burden the courts in the calculation of loss.
Okay. I also understand that the Commission, through this new loss definition, has adopted a net loss approach, or the idea of crediting. Could you tell us about crediting and a little bit about how it works?
Yes, the general concept of net loss is consistent with the overall philosophy of loss being the proxy of seriousness and culpability. And the sense is that if a perpetrator returns value to the victim before detection of the offense, that person is less culpable, the offense is less serious than the other perpetrator who does not return value. So it explicitly articulates a net loss concept in calculating loss.
If you would walk us through an example of how crediting works. In this example, we have a defendant who's convicted of one count of bank fraud for false statements on a loan application. The original mortgage was worth $128,500. The current value of the house is $100,000. Now, the defendant was making timely payments over the course of a year on the loan, with $12,000 being paid towards interest, $500 towards the principal, and $1,000 towards escrow. So with this defendant having made payments against his mortgage, what sort of credits is he going to get?
Well, there are two important principles at work here in terms of the crediting context. One has to do with collateral. The amendment didn't really change the rule with respect to collateral, so that if there's collateral, there is a credit for the value of the collateral at the time of sentencing if it hasn't been disposed of, or if it has been, in the fair market value of the return. So in this case, we have a total potential loss amount. You reduce it by the amount of the collateral, here $100,000. Then you go step by step to look at the different parts of the question to make sure that you are applying the rules correctly. You see a $500 payment to principal. That certainly is a clear example of where the perpetrator, the defendant, returned value to the victim prior to detection of the offense and hence would be credited against the loss figure. Now, with respect to the $12,000 in interest, just as interest is not included in calculating loss, accordingly, the payment of interest does not suffice as a credit against the loss. So there would be no credit for the $12,000 in interest that the defendant paid. Finally, with respect to the $1,000 in escrow, again, that was not included in the loss figure in the first place and will not be credited in the determination of the loss figure here. So you basically have the $128,500 minus $100,000 for the collateral minus $500 for the principal to give you your loss figure.
Okay, so in this example, we're not including interest because it's a specific exclusion. We can't include it in the loss calculation. Are there any other limitations, though, on crediting that we may need to be aware of when making our loss determination?
Yes, there's some special provisions that the Commission made policy judgments on, and these arose generally in case law under the pre-amendment guideline, and the Commission made certain policy judgments. So, for example, in the area of fraudulent professional services, there was case law that allowed crediting for services provided for people fraudulently posing as doctors or lawyers, for example. And the Commission made the judgment that they didn't want the courts to have to worry about trying to determine what the actual value was of some service that may have been provided, such as, say, a medical test by someone posing as a doctor or the creation of a will by a person posing as a lawyer. That it's important to the people who are being served by licensed professionals to be able to trust them, and the Commission didn't want the court to have the burden of making that additional calculation. So there's no crediting for any value that may have been transferred to the victims in that situation. Similarly, in the context of where you have goods such as drugs that require regulatory approval, that give the public confidence in the quality and safety of drugs, for example, the Commission decided that although there may be some value that gets transferred that would normally get the crediting rule, that it is so important for the regulatory approval process that the Commission decided that if somebody fraudulently obtains regulatory approval for example, a drug, or fraudulently claims that they have such approval, even if there may be some value in the medication or drugs or in the context of certain foods, there will be no crediting for that value. Finally, in the context of investment schemes, and one of the most frequently mentioned of this is the Ponzi schemes, where someone is trying to rip people off and to help induce others to risk their money, to invest their money, they give some of the earlier investors some of their money back or more of their money back. And this led to a three-way circuit conflict. The Commission adopted a rule that was essentially the rule of the 11th Circuit in the Orton case. It's sort of a middle ground between two extremes. The Commission decided that just as in the net loss rule generally, credit would be given where money is returned to an investor up to the amount of that victim's investment. But for a particular investor who received a profit, that profit portion would not be credited.
Okay, can we go through an example to better illustrate that? Because sometimes it's easier to understand through an example. So let's look at this next example. We have a defendant who is participating in a fraudulent investment scheme. What this defendant did was called 20 people and convinced them each, 20 people each, to invest $100,000 in the scheme. 5 of that 20 actually had $100,000, the amount of their original investment, returned. 5 additional people had beyond their original investment. They had $110,000 returned. None of the remaining 10 received any return. So when you're talking about crediting in an investment scheme such as this, what is our defendant going to get credit for?
Did this happen back when the stock market was so high 3 years ago?
I'm not exactly sure when it happened.
All this money around.
But I know it happened.
So we have 20 people who invested a total of $100,000 each, which is $2 million. And it's best to go step by step to differentiate the kinds of people to make sure that the rule is applied correctly. So for example, we have 5 individual victims who invested $100,000 and received $100,000 back. Each of those, or the $100,000 times 5, the $500,000 that they received back would be a credit against the $2 million. So that reduces it to $1.5 million. That's potential for loss. Then we move to the next category in the example. We have 5 victims who received $110,000 back on their $100,000 investment. Again, they would get the credit for the $100,000, but in this case, the profit that each received, the $10,000, would not be credited. So there would be an additional credit, therefore, of the $500,000. So we're down to $1 million. Okay. And the other investors received no money back. So the loss under this hypothetical would be $1 million.
Okay, thank you. So far, we've talked about the concept of reasonably foreseeable pecuniary harm. We have touched on specific exclusions to the loss definition, such as interest. We've also talked about this concept of net loss or crediting, and not just crediting, but where crediting may be limited in some instances. Are there any other special rules or special concerns that we need to be aware of?
There are a number of provisions that are characterized as special rules within the commentary to this guideline, and this is a perfect example of why it's so important to read commentary for each of the guidelines that's applicable. First, the credit card and access device provision. It provides a minimum loss rule for each credit card or access device of $500 per credit card or number. So notwithstanding whatever the calculation in the particular case is of the actual loss, there is a minimum loss amount that's provided by this rule that has to be followed. Secondly, there's a provision under the special rule listing for government benefits. Again, this is reinforcing the concept of the net loss rule. It resolves a circuit conflict, in effect overruling the Henry case from the 10th Circuit that had a different result. And essentially it's focused on government benefits are intended for certain persons and for certain uses. And the rule basically articulates that it's not all the money that's involved. It's only the money that excludes the money that actually went to the people and for the correct purposes. Because if a perpetrator gives some of the money to the right people for the right purposes, that person should be punished less than one who takes all the money. So that's why the government benefits provision is, again, reinforcing the net loss rule.
Okay. Just reinforcing that when it goes to the people it's supposed to go to, that's less harmful than going to people it's not supposed to go to.
That's right, even if it goes through a perpetrator who wasn't supposed to be an intermediary.
Okay. Well, we're going to take some time to have some questions now. We have a question here about loss, and we talked about how you cannot include cost to the government, or cost to the government in the prosecution of the offense. What about cost of the investigation incurred by the victim, for example, maybe a bank, like outside audits or employee overtime for investigating the offense? Is that something that might be included in a loss definition?
Well, the rule articulates, both with respect to government and the victims, that the costs that either, in this case the question deals with victims, the cost that the victim incurs primarily to aid the government in the prosecution and criminal investigation of an offense. So for example, years ago I prosecuted a bank embezzlement by a bank teller, and it was necessary to identify the bank, after the bank robbery, had to figure out what was missing, what happened, whatever. Those are the normal costs associated by a victim in figuring out the consequence of the investigation. But then we had to get the bank to hire extra experts to really lay out where the money went and how the money flow was. So those extra expenditures by the victim company were intended to help the government in the investigation and ultimately the prosecution of the offense. So those latter kinds of offenses, those extra costs to aid the government, are excluded from the calculation of loss, but the normal costs of a victim are included in loss.
Okay, so the distinction being between cost that the victim, loss that they are out of, versus what's being used to help the government in the prosecution or the investigation of the offense.
Essentially, yes.
Okay. Another question about the use of actual or intended loss and how they interplay with each other. In this scenario, we have a defendant who has stolen a number of checks. He's cashed $14,000 worth of those, but there are a remaining amount of checks that total $50,000 that he has not yet cashed. What is the loss going to be?
Well, on the surface, this question looks to be fairly straightforward, but it has some additional implications, and it's the kind of question like we received in a previous broadcast, I think from Charlotte, North Carolina, that, you know, kind of tricky, and we have to be careful with it. Generally, when you look at a theft of something like checks, and in this case, the theft of $64,000 in checks, the offense is completed at that time. The value is the value of the check. So in one sense, you could argue based on these facts that $64,000, the total, is the actual loss in the case. This raises the question, however, of what if you have some intended loss and some actual cost? Do you add the actual cost to the unrealized intended cost? And we're seeing some case law evolve, and I think it's important to check the case law on it. But the courts have some flexibility in determining intended loss. So if the court, in a case analogous to this one, determined that the defendant intended to rip off the $64,000 total amount, then I think it's likely that on appeal, that kind of a determination would be upheld.
Okay, so regardless of the fact that the defendant didn't actually cash that $50,000, the court could determine that that was an intention of the defendant and therefore include that in the intended loss, which would be greater than the actual here, which would be $14,000.
Yes.
Correct? Okay. A specific question about a specific offense characteristic at 2B1.1, B2A, the victim specific offense characteristic. We have a defendant convicted of credit card fraud. Now, when you're determining the number of victims for purposes of the specific offense characteristic, can you include the individuals as well as the credit card companies as victims for purposes of that SOC?
Well, the fundamental point with respect to that SOC, and it reinforces the point of that it's important to read the commentary and to not rely on perhaps everyday understandings of words. So here, the word victim has certain connotations, so that, for example, if somebody had a credit card stolen, even if it was never used, they could be considered a victim because they were victimized. Right. The Commission, in promulgating this rule that provides enhancements based on numbers of victims, the Commission decided to have a narrower definition of what a victim is. So it's important that that be followed in the application of this specific offense characteristic. Here, the victim is only someone who sustained an actual loss. In a credit card case, that could be a situation where it's the credit card holder, it could be the bank, it could be the credit card company, or it could be the credit card holder and the bank. They could have both suffered a loss, in which case they would both meet the definition, and that would count as two victims.
The crux of the issue being the victim having sustained an actual loss.
That's right.
Okay. What if you have a situation where the defendant is filing false claims with the insurance company? The defendant has, let's say, a car insurance policy that covers him up to $30,000, but he's filing a claim to get $40,000 back. How does that affect the loss calculation at all?
Well, that's an example of one of the circuit conflicts that the Economic Crime Package of Amendments resolved in the loss portion of it. There was some case law that led to a different result, but under the amended guideline for intended loss, the economic reality, in other words, what would happen in response to what the defendant did, in other words, what was actually physically possible, is not the determining factor. It is what did the defendant intend. So, for example, the case law that showed that in a reverse sting case out of the 10th Circuit, that because the agents couldn't have lost any money, there was no intended loss. Right. This rule is basically saying, and it supports the concept of culpability of the defendant, that if a defendant intends to rip off a certain amount of money, that is the amount of the intended loss.
Okay. One last question before we go to a break. We have a defendant charged with making false statements to acquire a loan for a boat. The amount of the original loan, the total amount of the original loan is $80,000. Now, the defendant's been making payments on this loan, and the loan is not in default status. Is he going to get credit for these payments, and is he going to get credit for the boat even?
Well, the defendant is going to get credits for payments on the principal, just as in the example that we talked about before. Mm-hmm. The general concept of collateral is fundamentally important. If the boat was collateral for the loan, then it can be credited against the total loss amount. Mm-hmm. If the boat was not collateral, but the boat was returned to the victim before detection, then it would be credited under the crediting part of the rule.
Okay.
And I'd refer people to a case that deals with the collateral issue, is the McCormick case out of the Ninth Circuit, and that was an October 29th, 02 case that helps look at the rule on the use of collateral for crediting.
Okay. Well, that wraps it up for the questions that we have for economic crimes. Thank you for joining us today. We appreciate you being here. And we're going to take a 5-minute break, and we're going to resume with a discussion of money laundering. Welcome back. We're going to spend the rest of our time today talking with Paula Desio about money laundering. Paula, welcome to the show today.
Thank you. Nice to be here.
Good to have you. Why don't you get us started with money laundering by just telling us a little bit about the money laundering amendment?
Okay. Well, at the same time as the Commission revised the economic crime package, it also revised the money laundering guideline. So there is a new money laundering guideline in effect since November 1st of 2001. And this new guideline is, in essence, a consolidation of two previous guidelines, 2S 1.1 and 2S 1.2. Now there is a single money laundering guideline that covers two of the primary money laundering statutes, which are found in Title 18 U.S. of the United States Code, Sections 1956 and 1957. And 1956 has a 20-year statutory maximum, and 1957 has a 10-year statutory maximum, and the guideline takes that into account, as you will see as it's played out and we explain the structure of the guideline.
Okay. I've heard this concept of a specified unlawful activity. Could you tell us a little bit about that?
Certainly. The specified unlawful activity is central to the money laundering statutes in the criminal code. Both 1956 and 1957, the two primary federal money laundering statutes, require that there be a specified unlawful activity, which is the underlying activity that gives rise to the money, the proceeds, and those proceeds are in turn laundered. But to have money laundering, you need to have some specified unlawful activity, something illegal that causes funds to be generated in the first place, such as drug trafficking or certain types of fraud. Now, specified unlawful activities are listed in the criminal code at 18 U.S.C. 1956 sub 7 sub A sub C. And in there, you'll find the specified unlawful activities. Now, the Commission, in its revised money laundering guideline, built on the specified unlawful activity concept and uses the offense conduct of the specified unlawful activity as a basis for the guideline calculation for money laundering conduct at sentencing.
Okay, so in other words, the Commission has adopted the approach of holding those defendants who are responsible for the underlying activity more accountable, per se, than those defendants who are not.
That is correct. If you look at the reason for the amendment, the Commission specifically stated that the purpose of this amendment was to tie the money laundering sentence more closely to the crime that generated the proceeds of the money laundering in the first instance.
Okay, so taking that approach, what is the key issue, if you will, that one has to determine when faced with a money laundering offense?
Well, the key issue is to ask how the defendant committed the money laundering conduct. The first question is essentially, a key question is the defendant a direct money launderer or a third-party money launderer? Mm-hmm. A direct money launderer is someone who has committed the underlying offense and generated the proceeds himself or herself and then laundered those proceeds. Mm-hmm. Or the defendant, and the way that that is determined is by looking at the first prong of relevant conduct at 1B 1.3 A1A to determine if the defendant committed, aided and abetted, caused, or induced the activity. Okay. If the defendant did that with respect to the underlying offense that generated the proceeds, that defendant's a direct money launderer.
So it's a very limited scope, a limited application of relevant conduct in only those defendants who aided, abetted, counseled, commanded, and that the underlying offense. What if the defendant is not responsible for the relevant conduct under that first prong?
If the defendant is not responsible, as he would not be responsible for the acts of other participants in the underlying activity, if that were determined, then that defendant would fall into the category of a third-party launderer. Okay. And the sentence would be calculated somewhat differently under this guideline.
Okay. Since we've mentioned the sentence calculated a little bit differently, once we've determined whether we have a direct money launderer or a third-party money launderer, how do we determine what the base offense level is?
Well, the way that the base offense level is determined for a direct money launderer is to start with the specified unlawful activity. That is fundamental to this guideline. And find the guideline that corresponds to that specified unlawful activity. If the specified unlawful activity was fraud that generated the proceeds, then you look to the fraud guideline at 2B 1.1. If it were drug conduct or drug trafficking, then you go to the drug guideline and so forth. And at that point, you do what I call a full workup under the underlying guideline. You look at the base offense level, and you also include any relevant, any specific offense characteristics and corresponding enhancements for that guideline. You total all of that up, and then you literally bring it back into 2S 1.1 and use that as the base offense level for money laundering.
Okay, so that's for direct money laundering.
That's
going
correct.
to the underlying offense, applying that entire guideline, and then coming back to the money laundering guideline.
Correct.
Now, how is it different for those defendants who did not commit the underlying offense, or those third-party money launderers?
Well, it's different necessarily because, as we said, a third-party money launderer is not involved in the underlying offense conduct that generated the proceeds. So the calculation has to be different. They can't be tied to that conduct.
Okay.
So therefore, the Commission determined that the way to proceed would be to take a base offense level of 8 for that third-party defendant, and then to that add the value of the funds that are laundered. Here, the value of the funds that are laundered becomes very important, and consult the monetary table at 2B 1.1 for the appropriate enhancement level, and add that to the base of 8. And that gives you actually the complete base offense level for the third-party money launderer.
Okay, so we've talked about determining whether your defendant is a direct or a third-party money launderer. Both of those base offense calculations refer either in full in the case of a direct money launderer or in part in the case of a third money launderer to another guideline. But you also mentioned that we come back to the money laundering guideline.
That's correct.
What do we come back to the money laundering guideline for?
Okay, you come back to complete the calculation, because if the defendant is being sentenced for a money laundering offense, it's consistent that the defendant be sentenced under 2S 1.1. So the base offense level has been determined, and then there are a number of SOCs, specific offense characteristics, that apply to money laundering, because money laundering is a separate and distinct offense in the criminal code, and it will be separate and distinctly punished in addition to the underlying offense conduct.
Okay, so there are specific offense characteristics for the violations, either in 18 U.S.C. 1956 violation or an 18 U.S.C. 1957 violation.
That's correct.
Correct? But then there are additional specific offense characteristics depending on which statute the defendant violated?
That's correct.
Okay.
As I said at the beginning, 1956 has a 20-year statutory maximum, whereas 1957 has a 10-year statutory maximum. If the conviction is for 1956, the defendant receives a 2-level enhancement, and if it is for 1957, which has half the statutory maximum, it receives an enhancement. The defendant receives an enhancement of 1 level, which is half.
Okay. If we have a defendant convicted of a 1956 violation and gets that 2-level increase, tell us about the sophisticated laundering enhancement that can then be applied after that.
Well, if a defendant has a 1956 conviction, there is another possible enhancement for that defendant, whether he is a direct or a third-party money launderer. If the defendant has engaged in sophisticated laundering, and again, as Andy pointed out, you need to look at the definition in the guideline, in the commentary, as to what sophisticated laundering means. For guideline purposes, it means whether the defendant has created fictitious entities, used offshore bank or other financial accounts, had multiple layered levels of financial transactions, or created shell corporations in which to hide assets. That would be considered sophisticated laundering and would merit a 2-level enhancement.
Okay, and that would apply to both direct and third-party money
Correct.
launderers. Are there any specific offense characteristics that would apply to either only direct money launderers or third-party money launderers?
Yes, third-party money launderers have the possibility of 2 of their very own specific offense characteristics. The first is a 6-level enhancement that applies when the defendant who has laundered illicit proceeds knows that the source of those proceeds is from one of several enumerated crimes, such as terrorism, drug trafficking, sexual exploitation of a minor, and crimes of violence. The defendant would receive a 6-level enhancement in addition to the 8 that applies to a third-party money launderer. That's a third-party money launderer specific enhancement.
Okay.
And there is one more for a third-party money launderer. If this money launderer is convicted of 1956, which we've been talking about, he or she is also eligible for an additional 2 levels if it's found that that third-party launderer is in the business of laundering funds. Someone in the concept of offense who constantly provides an outlet for stolen goods, if someone is in the business of laundering money, they are subject to a 2-level enhancement. And that determination is made, if you consult the application notes, based on the totality of circumstances that the judge may consider, such as the frequency with which this defendant has laundered money, prior convictions, the amount of money, and other similar factors.
Okay, great. Well, we've talked about determining base offense levels. We've talked about the different specific offense characteristics relative to the type of money laundering offense. I want to touch on a point about Chapter 3 adjustments. Is there anything specific that we need to remember when applying Chapter 3 adjustments to money laundering offenses?
Yes, I think it's very important to keep foremost when using this 2S1.1 revised guideline that Chapter 3 adjustments apply to the guideline that governs the statute of conviction. Even when referring to another guideline for the underlying offense conduct, the Chapter 3 adjustments have to apply to the money laundering conduct, not to the underlying offense conduct.
Okay, okay. I understand that the Commission resolved a circuit split regarding grouping of money laundering with the underlying offense. Can you tell us about how that was resolved?
Yes, there were circuit splits over the issue of whether the underlying offense conduct for which generated the proceeds that the defendant laundered should be grouped under the multiple count rules with the money laundering conviction. And some circuits said yes, and some circuits said no. So at the time of revising and amending this money laundering guideline, the Commission determined it was proper to have grouping precisely because this new money laundering guideline builds on the underlying offense conduct and builds it into the calculation of the guideline sentence.
Okay, so we can group money laundering with the underlying
now
offense.
Yes,
okay.
Definitely.
And what rule would we be grouping those
There
under?
is a specific rule in the money laundering guideline that states that money laundering is to be grouped with the underlying count of the underlying offense that generated the proceeds if there is a companion conviction for that, pursuant to Rule 3D 1.2c.
Okay.
And there's a companion application note 6 that explains that.
And there's that specific instruction at the money laundering guideline because it's a deviation of the normal Rule C, correct? In that it's not a pulling of a specific offense characteristic to group the 2 counts, but you're looking at the base offense level from another count. So that's an exception to the regular Rule C grouping.
Yes, absolutely. Okay. And it is tied to the inherent nature of the money laundering guideline and how money laundering is tied into specified unlawful activities and underlying offense conduct.
Okay. I want you to walk us through a couple of examples, but I have a question first about the issue of whether this amendment is clarifying or substantive. I understand that the court has the final decision in determining whether an amendment is clarifying or substantive, and they need to use Appendix C and the reason for the amendment to make that determination. Are there any courts that have come down on that decision on whether it is either a clarifying or a substantive amendment?
Yes, there are a number of courts because this issue was raised immediately after the guideline went into effect as to whether this guideline should be would be retroactive. The Commission did not make the amendment retroactive, and the issue was raised as to whether it was substantive or clarifying in an effort to try and have the guideline made retroactive by some petitioners. But 2 courts, the Second Circuit in United States v. Sabbath and the Fifth Circuit in United States v. McIntosh, both held that the amendment was substantive.
Let's go ahead and take a look at some of our specific examples here. In this first example, we have a defendant who has defrauded investors of a total of $800,000. He's laundered $60,000 of that $800,000. $45,000 he's paid toward his mortgage, and $15,000 he's opened up a CD in his wife's name. Now, this particular defendant is convicted of 3 counts of violating 18 U.S.C. Section 1957. Where do we begin with calculating this defendant's offense level?
Okay, we go to the guideline 2S1.1 and we ask, is the defendant a direct or a third-party money launderer? Does he fit under subsection A1 or subsection A2? In this case, it seems clear that the defendant himself has been engaged in the fraud against the investors. So the first step is to say, what is the guideline for fraud? And that is 2B1.1. You go there and you take that base offense level, which is 6, and then you look at the amount of the loss, which here appears to be $800,000, and based on the monetary table in 2B1.1, that is a level 14, or an enhancement of 14. Mm-hmm. That is added to the base offense of 6. And then just for example, you take any other applicable specific offense characteristics. Let's just say here that there were more than 50 victims in this large fraud, then the defendant would also receive a 4-level enhancement for multiple victims under the table for 50 or more victims. That would be 4 more. Okay. So 6 and 14 and 4 would total to a level 24. Now that 24 from the fraud would be carried back to money laundering and would be the base offense level under subsection A1 for this money laundering defendant. And then specific offense characteristics for money laundering are added. In this case, the only one that I see applying would be the 1 level for the 1957 conviction. Okay. So the total would be 25.
Okay. Now, I know that this example, our defendant acted alone. He actually defrauded all of these people out of $800,000 on his own. But let's change the facts a little bit and say that he recruited some help and had 15 people working for him, and they all together defrauded these folks of $800,000. Would this defendant then be eligible for the aggravating role?
Not in this case. On the facts presented here, the defendant is only convicted of money laundering, and Chapter 3 adjustments are going to apply to the money laundering guideline. Okay. And it seems to me from these facts that he acted alone in the money laundering conduct.
Right.
Now, if the facts were different and he was also convicted of fraud, then he would get an aggravating role for the fraud conviction, but not for the money laundering.
Okay. Okay. Let's look at another example. In this example, we have a defendant who is a car dealer and knows that the purchaser of 2 new automobiles is a drug dealer who has no other legitimate source of income. Now, these 2 cars total $150,000. That's their worth in total. And we have a defendant convicted here of 18 U.S.C. 1956 A1BI. Now, this defendant knows that the guy buying the cars is a drug dealer. Okay. Is that enough to make this defendant a direct money launderer?
No, it isn't, because unless the defendant himself committed the drug dealing or aided and abetted it or was somehow very directly involved, he cannot qualify under the first prong of relevant conduct as defined for the money laundering guideline. He will not qualify as a direct money launderer. So this is basically your classic third-party money launderer. Okay. He takes money generated by another person illegally and helps to wash it, put it into the stream of commerce.
Okay. So we're determining the base offense level on the basis of a third-party money launderer.
Correct.
And we go to only the loss table at 2B1.1.
That's correct. What we do is we take, first of all, in the money laundering guideline under subsection A2, you take that level 8 that the Commission has provided. Then you consult the monetary table at 2B1.1, which you said here you have $150,000 under the monetary table at 2B1.1. That would be a level 10. That's 18, and then you look at the specific offense characteristics for which this third-party launderer is eligible. And in this case, it sounds as if he knew, it would be established at the sentencing hearing that he knew that the proceeds were from a drug trafficker. And that is one of the offenses listed that makes him eligible for the 6-level enhancement, where he knew that the source of the proceeds was one of the activities listed in that particular enhancement.
Okay, great. I think we have time for one question. We have a defendant who is a direct money launderer. And in this case, the underlying offense was distribution of drugs. Now, do you use full relevant conduct for the underlying offense when you go to the drug guideline? Do you use all of the drugs that the defendant distributed, even though he only laundered a small portion of the proceeds?
Yes, you do use the relevant conduct for all of the drugs. If this is a direct money launderer, you go to the underlying the guideline that corresponds to the activity that generated the proceeds, and he is held accountable for all of the activity there. You are not using the value of the funds here. You're using the underlying activity. This was part of the Commission's intention, that the money laundering be tied to the offense that generated the proceeds. And then it is built upon, and specific offense characteristics are added to that, enhancements are added to that.
Okay, so it would be the full relevant conduct of the drug behavior, not just the drugs associated with the money, the proceeds that were laundered.
Correct.
Okay, okay, thank you. Well, thank you for being with us today.
Thank you.
That wraps it up. We've run out of time. Thank you also for being with us today. If you would like further information on money laundering or economic crimes or any issues related to sentencing and guidelines, please visit us at our website, which is www.ussc.gov. If we were unable to get to your questions today, or if you have any other questions, feel free to call us on our helpline. That number is 202-502-4545. And we operate the helpline Monday through Friday between the hours of 8:30 a.m. to 5 o'clock p.m. So keep that in mind, those of you out on the West Coast. Again, thank you for joining us today, and have a wonderful afternoon.